So how much time does it take to get a patent? This is probably the top question I get is, well, how long does this process take? I gotta get my product to market and make money now. Did you know that you can do something called a track 1 or prioritized examination and get to the front of the line and save you a ton of time in getting your patent prosecuted? We'll figure that out today with a lot more information as we talk further. My name is JD Houvener. I'm a registered USPTO patent attorney, managing partner here at Bold Patents Law Firm. And I am dedicated to talk with you today about the timing considerations to let you know how long does this patent process take. As we go along, I want to let you know my editing team has put a table of contents so you can fast forward, rewind, replay this content and jump to the section you want to discuss. We're going to talk about quite a bit today, and so you're going to want to make sure you bookmark this link, share it, and like the video so we can share this with as many people as possible. I also encourage you, right, if you don't like the content or you're confused with something I say, put a comment below. One of our team or I personally will be able to respond to one of your questions. So thank you in advance for your help and participation. All right, so how long does it take? What does that really mean? What are the tidbits here? So I want to break it out into different types of patents that you can file and try to help you understand the process that way. So a provisional patent application, right? We hear a lot about provisionals. You may have seen on Shark Tank, or you might have seen on other shows where they're talking about how they're patent pending. So a provisional is an informal way for you to get a patent application date, right? That date, the all-important filing date, because it is now the current system in the US that rewards the first inventor to file. Not necessarily the first to invent, but the first one to get their invention filed at the USPTO using a patent attorney. So a provisional will allow 1 year and no more, right? 12 months, 365 days, baby, to get your non-provisional, right? That formal patent application submitted. So you've got that full year to then go to market, share your invention with investors, right? Maybe sharks or real good folks that you know, angel investors, venture capitalists that may want to put their capital into what you're working on. And what's so nice about having that filed is that you no longer need to keep whatever you're discussing confidential, right? If you're only discussing what you filed, that is that whole time period. Okay, so you have that 1 year. So that's a definite timing consideration. The other aspect of this, kind of taking it the other angle, is that yes, that does mean that you're sort of building in a year into the whole time scope, meaning you won't actually have enforceable patent rights for until the patent gets granted. Okay, so if you're filing a provisional, that means you're adding necessarily up to a year in the process, and so that could mean that you may not be able to go after infringers as quick. And so that's also why we recommend for those that are in software or high tech, right, places that are innovating very quickly, to instead of filing a provisional, to file a non-provisional as soon as possible. That way they're able to get their patent rights sooner. Okay, little trick of the trade. So let's jump to what a non-provisional means. So right after that year or however long you take to develop your product in the provisional phase, a non-provisional, once submitted, can take anywhere between 9 months and 4 years. Yeah, you got that right. Once it's submitted to the patent office, it could take up to 4 years to get patent rights granted. So don't think this is going to happen overnight. Get your watch out and just start to work. Okay, you've got to let the federal government do their thing. All right, they go through their own process internally with assigning your invention a classification, identifying an art unit, which is a technology specific group, where one examiner, right? One examiner is going to be assigned to your case, and they're going to be working on your patent application until it gets granted. So you're in a sense stuck with them. So one other tip on examiners I want to mention is that we use all the time is there's a wonderful site called Examiner Ninja. All right, and there's a couple other sites out there, but we love this one because it shows the statistics on each examiner and kind of the tips and what they tend to do well with, right? Whether it's worthwhile, for example, to invest effort into doing an examiner interview, and whether it makes a difference to go in person or through video and to walk through what the examiner found when they did their research. And so sometimes it's not worth it at all to do the interview, or it's better to just do legal argument and stay off the phone, right? Some examiners have different communication styles, and so those are the real trade secrets I'm letting you know that today because that's how I'm willing to make a difference in your personal inventor journey, right? I'm really invested in making sure you see success. I hope and encourage you to work with our firm at Bold Patents, but no matter what, I want you to have the information so you can make a difference in this world in the most efficient and effective manner. So let's walk through the other types of patent applications, okay? So plant patents, and I've got a really cool blog I want you to visit below if you're really curious about plant patents, all right? So plant patents are all about protecting organic things that grow out of the earth, okay? So it's really a plant. It's not about an industrial plant with smoke coming out the top. No, it says organic created elements, okay? And there's certain requirements about what it takes to be able to protect those. So if you're curious about that, please visit the blog and the video I'm going to do on plant patents later. So plant patents typically are shorter. So sometimes 1 to 2 years is how long it will take to get that patent granted. Why? Well, because there's just fewer of these applications out there. There's only on the order of 40 to 50,000 plant patents that have ever been issued. Take that in comparison to 10 million utility patents that have been issued. I mean, the pipeline just a whole lot bigger. So plant patents get a separate art unit and get assigned to examiners that just flat out aren't as busy. Those get prosecuted quicker, okay? Next is design patents. Design patents, as you probably have heard before, only protect the ornamental appearance and the way something looks. There's just less in that application. It's only drawings. If you've ever looked at the spec, the written description of a design patent, it's only 1 page long. Right? It just talks about who the title is, the inventor, and the one claim that says, go see the drawings to learn about what this invention is all about. So the substance, the amount of effort it takes to review, do an examination, and provide an opinion on that for the examiner is really limited. And so the time in prosecution tends to be between 1 to 2 years, often quicker than that. If you're enjoying this, please like it. I want you to make sure we know that we're doing well, to keep doing more of these, to keep educating folks like you, inventors, scientists, entrepreneurs, folks chasing their visionary idea. It's my goal, my whole mission in life, in this career, is to educate inventors. And so if I'm not doing my job right, if you have questions or it's not making sense, you gotta put the comment in, ask a question. I will personally make sure you get a good response, all right? And so also, I wanna put a quick plug in because I put a lot of effort into this book. I compressed, all my knowledge in patent law over the years into this super skinny, 1 hour read. Bold Ideas, The Inventor's Guide to Patents. It's yours for free at boldip.com/free. Get your copy today. What I wanna talk about now is sort of these really cool tricks, okay? And so I call them tricks, but they're really part of everyday practice for us now. But I'll give you a story. When I just started out, okay, relatively new, 1 or 2 years out, I was working with an inventor and been working with him. He's across the country in the Boston area and innovating in this area of chemical solids and powders, okay? And we're working through the prosecution, and we've already submitted both the provisional, submitted the non-provisional, and now we're waiting to hear back the office action response. It's been 14 months, and this inventor is just like, what's going on, JD? This is insane. This is taking way too long. I want my money back. I want to know answers. I want to talk to the patent examiner. And I just keep telling him, look, I'm so sorry that the patent office hasn't assigned an examiner yet. This art unit was just way backlogged. And I took a look at some other options. I went and dug through. I said, okay, yes, Mr. Client, I'm going to go see what I can do. And I found the fact that examiners will prioritize, right, give primary access to those inventors that are 65 or over. And I started wondering, oh, wow, interesting. I wonder if this client is over the age of 65. And I never asked, right? It wasn't part of our process to ask how old the inventors are. I happened to ask. The client was 67. I put the petition, which is no cost to do the petition, and within a week, we got an office action response. Obviously, it's part of our process now to know how old all of our inventors are, and so boom, it's done. We get those petitions filed as soon as we can. So why in the world would the patent office do that, right? Well, they want to make sure that you, the inventor, are going to get your money's worth, right? Make sure you see the reward that you're supposed to get for coming forward and sharing your innovation with the world. 20 years is a long time, so they think, okay, they're already 65 or older, they're going to be 85 or 90 by the time this thing expires. Let's get them to the front of the line. It turns out there's actually several ways to get to the front of the line using a petition to make special. If your invention has to do with an environmental improvement, an energy savings improvement, right? Energy generation or storing capacity, or it can improve national security. Those are special subject matter specific rules that will allow your invention to get to the front of the line. You could get an office action feasibly within weeks or a month, whereas it normally takes over a year. So it's an incredible fast forward. If you're innovating in that realm, we will file a petition every single time. It doesn't cost a thing to ask to get to the front of the line. Now, there are also ways to pay the money, right? Payola, it's America, right? Capitalistic economy. Yeah, you can pay $2 or $3 or upwards of $4,000 depending on the size of your entity. And you can pay for what's called Track 1, Prioritized Examination. And we file this all the time for corporate clients and for some individuals that are well off that don't mind paying that extra fee to get that same priority treatment and getting their examination done right away. So just remember the fact that the earlier the examination, that generally means the sooner the patent will get issued. And as soon as the patent's issued, that's when you can start enforcing your rights, litigating, licensing, and really getting the full appreciation of that asset. So I've covered some of these tricks of the trade, but just know that, yeah, it does take some time. This is not going to happen overnight. A patent process can generally take between 2 to 4 years. And I tell people that because, that's the truth. And they need to understand and acknowledge the fact that they can't just sit and wait for the patent to get granted. It's almost always worth it to get started. And you should legally, make sure there's really market potential for your product while this is going on. So it's both and, right? You can produce your product, sell it, have commercial success while your patent is pending. And that's why this whole process is in there to begin with. That's why we are in place as your patent attorney, your advocate, to help cheer you on to make a difference in the world. Have a great day, everybody. Go big, go bold.
Go big, go bold.